Hello everyone, I am Pavandara. I am pursuing my LLB from Karnataka State Law University after having worked for nearly 12 years as an HR with few of the big corporates after finishing my MBA. Today I am here to discuss on the topic family courts. Under this topic, let us discuss introduction and history of family courts, concept and need of family courts, establishment and composition of family courts, jurisdiction, duties and powers of family courts. In Western countries, the family courts are functional from a very long time. But in India, till 1984, the family disputes were heard by the traditional, the ordinary civil courts. As the population was growing in India, along with the long pendency of civil and criminal disputes, it was very difficult for the traditional courts to give speedy solutions. At the same time, population was growing and the number of disputes were increasing due to the Western culture and due to the individual earning and life leading capacity. Both 59th Law Commission in the year of 1974 and the Committee for Status of Women in the year of 1975 submitted in their report mentioning the very essence of establishing special courts for the family disputes. Most of the other women organizations, NGOs, intellectuals, think tanks, judicial fraternity, and individuals pressurized the government to pass an enactment to establish family courts in India. As a result of that, in the year of 1984, central government passed Family Courts Act. Establishment of family courts. The Family Courts Act 1984 is applicable to all India except the state of Jammu Kashmir. But after the abolition of Article 370 on October 31st, 2019, now the Act is also applicable to the state of Jammu Kashmir. The different states have adopted the Family Courts Act on different dates. For example, Karnataka adopted this act in the year of 1984, Delhi and Madhya Pradesh in the year of 1986, Tamil Nadu in the year of 1987, Kerala state in the year of 1989. The state government, in consultation with High Court, can establish one family court for every 1 million population. The state government can also establish family court in any other area of the state wherever it deems necessary. In consultation with the High Court, state government can increase, decrease, alter the local limits of the family court. Appointment of judges. In consultation with the High Court, the state government can appoint one person as a principal judge and it can appoint additional judges if it feels necessary. The qualification of judges. Point number 1. A person should have at least worked for 7 years as a judicial official or a member of a tribunal or in any post of central government or state government in which it requires the special knowledge of the law. Point number 2, a person should have worked as an advocate of High Court for at least 7 years. Preference shall be given to the woman. It should have any special knowledge as prescribed by the central government in consultation with the Chief Justice of India. Retirement age would be 62 years. Salary or the honorarium will be decided by the state government in consultation with the High Court. The family courts shall have and exercise all the jurisdictions of a district court or any other subordinate civil court. And on the date of establishment of a family court in any other particular area, any family dispute which is under the process shall get transferred to the family court of that particular area which is established on that particular date. The family courts shall have jurisdiction to decide upon the matters related to the marriage disputes with respect to point number 1, restitution of conjugal rights. For example, under Section 9 of the Hindu Marriages Act 1955, for Muslims under Muslims General Law, for Christians under Section 32 and 33 of Indian Divorce Act 1869, under Section 22 of the Special Marriages Act for those who have got married under Special Marriages Act. Point number 2, validity or annulment of marriage. For example, in the case of Shafin Jan versus Ashokan KM, popularly known as Adya case. In this case, Miss Akila Ashokan got converted as Muslim and got married to Mr. Shafin Jan. But the parents of the girl approached the court and the court held that the marriage is invalid. But Mr. Shafin Jan approached the Supreme Court and the Supreme Court held that the marriage is very much valid. Point number 3, judicial separation. Point number 4, dissolution of marriage. Point number 5, any issues related to property sharing. Point number 6, any issues related to maintenance. Point number 7, any issues like injunction orders with respect to domestic violence or any other cases. Duties and powers of family courts. Point number 1, family court should make all the possible efforts to settle the matters in a very amicable way. It should make all the possible efforts and try to persuade both the parties to settle the issue in a very positive way so as to save the marriage. Point number 2, except under Chapter 9 of CRPC 1973, a family court shall be deemed as a civil court and it shall have all the powers of such courts. Point number 3, proceedings to be held through camera. If the family court and the parties feel it necessary to have the proceedings through the camera, the family court shall do so. Point number 4, assistance of medical and welfare experts. Whenever family courts feels it very necessary to take the assistance of medical experts and the welfare experts, it shall do so. Point number 5, representation of legal experts. Normally, family courts do not entertain the legal representation by either of the parties. But if the family courts feel necessary to allow a client to bring upon his legal representative, it shall do so just to secure the end of the justice. Point number 6, application of Indian Evidence Act 1872. The court will receive the statements, document, information and it will record them. If it feels those evidences will enable the family court to proceed effectively, it shall do so. Point number 7, evidence on formal affidavit. The family court shall accept the evidence on the formal affidavit and it may call the people for any furthermore inquiry who are giving such affidavits. Point number 8, oral evidence. Of course, the family courts, if the court feel necessary, it will record the oral evidences of the witnesses and the parties. Point number 9, judgment. The judgment of the family courts will have a brief about the case and the points for consideration and points for determination and decision thereon and reasons for such judgment. Point number 10, enforcement of decrees and orders. Except under Chapter 9 of CRPC 1973, the orders and the decrees passed by the family courts shall have same effect and force just like any other civil court. Appeal against the order or decree passed by the family courts. In every order or decree passed by the family court, there shall be an option of appealing to the High Court in respect of both on facts and on law. But such appeal should be made within 30 days of the judgment. No appeal shall lie in the order or decree given by the family court in case of mutual consent of the parties. Conclusion. The issues like divorce, nullity or validity or judicial separation or maintenance issues should not be viewed as success or failure of legal battle. Rather, these things should be viewed as social therapeutic problems. Thank you so much.